This conference will now be recorded.
So welcome everybody. Today is March 3rd, 2021, and I'm happy that you're joining me for today's webinar, Bringing Your Durable Power of Attorney into 2021. And it's a great way to start off a new year by making sure that your or your client's affairs are in order. So in order to know what we have to do to bring an existing durable power of attorney into 2021, we really need to start with a basic understanding of what is a durable power of attorney, why is it important, and how does it differ than what you might hear called a general power of attorney. So a durable power of attorney in Florida is a legal document that gives every adult over the age of 18 the opportunity to designate somebody that they trust to make financial decisions for them when they might become incapacitated. Now, incapacitation has a very broad meaning. It could mean that physically somebody is disabled or infirm, and that's affecting their ability to make what we consider to be some basic financial decisions, things that we probably take for granted, and we do daily, maybe once a week, once a month. And that could be something as simple as writing a check, going online to make an online payment, talking with our financial planner, our accountant, perhaps making a change in our investments, or we're in March now, so pretty soon there's going to be the deadline for all of us to file and sign a federal income tax return. So if we're incapacitated, either physically, cognitively, or mentally, we might be unable to make any of those kinds of financial decisions. The reason that the document name starts with the word durable is why this is such an important document. It means that there is special language in the document that says, notwithstanding our illness or disability, our financial agent's legal authority to make financial decisions for us continues. It does not stop. The only time it's going to stop is going to be at our death. So the whole reason to have the document is to help us get through a time of disability, illness, or incapacity. Once we pass away physically, the purpose of the document has been served. So there's no longer a need for the durable power of attorney to be used. After death is when we would determine who is the fiduciary that is designated either under a last will and testament or perhaps under a trust agreement. So if that durable language is missing from the document, that's a good reason to get your document updated, because it's not enough to just have the word durable in the title. That magic language has to be in the document itself. Something very important for everybody to understand is that when we sign a durable power of attorney, we are designating a trusted person that we call a fiduciary. That fiduciary is held to a high standard of care in making decisions for us. So we are not making that fiduciary an owner of our assets. And for that reason, many people consider the durable power of attorney to be a much safer way of safeguarding our assets and at the same time being able to make financial decisions for us. Now, how is the durable power of attorney different than what you might hear called a general power of attorney? So the difference is that a general power of attorney is written for a very specific and limited purpose. For example, Someone may come from another country or another state to Florida to look to buy a second home or a rental property. And they sign the contract, they pay the deposit, and they go back home, but they don't want to have to come back here physically to complete the closing. So they may hire a real estate attorney and give that individual a general limited power of attorney just to sign the closing documents for them. There's no other authority given to make financial decisions. So that document can only be used for that limited purpose. It's not going to have that magic durable language, and so it's not going to help the client should the client become incapacitated. So who do you think needs a durable power of attorney? Well, anybody over the age of 18 is considered a legal adult. Yes, that means our high school students who are graduating high school in May, might be going off to college, might be enlisting in the military, and maybe we as parents think they don't have the maturity or the life experience and wisdom to make good decisions. Believe it or not, as parents, we're no longer going to be able to make financial decisions for them. So anyone over the age of 18 should have a durable power of attorney to cover them in the event there's an accident or an illness. Now, in order to sign a durable power of attorney, it's important that the person have a certain level of awareness. They should be able to reason as to why they're choosing a certain individual to make their financial decisions, and they should have the ability to exercise good judgment. This shows us that the person is oriented, that they're knowledgeable about what their assets are, their income sources, and who their family is. So this is very similar to the standard that we use to determine if a person has legal capacity to sign a will or a trust. It's considered to be a very high standard because this is a legal document that is delegating a lot of financial decision-making authority. So it's not enough that the person can hold a pen in their hand and sign their name. They truly need to understand what they're doing by giving permission to another person to make financial decisions for them should they become incapacitated. Now, somebody could be mentally competent, have capacity, but perhaps they have a physical disability. They might have Parkinson's, and so they might have a tremor, which would cause their signature to be illegible. That's okay because Florida has a wonderful notary law that allows the notary to sign for the individual that has the physical disability. And so because of this wonderful notary statute, it doesn't prevent somebody with a physical disability from having a durable power of attorney. What the notary must do is ask the individual in the presence of the witnesses, would the person like the notary to sign the document for them? And the client must speak as opposed to nodding their head unless there is a speech issue. They must give their consent to have the notary sign. So in order to truly appreciate all the benefits that we get by having a really well-written durable power of attorney, we have to first understand what happens when you don't have a durable power of attorney and you become incapacitated. Well, most people are shocked to learn that simply by being married doesn't give a person the authority to make financial decisions for their spouse. Similarly, we might be single, we might be divorced or widowed, And we could have adult children, but merely by being our children doesn't give them permission either to make financial decisions for us. Now that comes as a surprise unless the spouse or the adult child's name is on the asset along with the person who's incapacitated. So for example, if I became incapacitated, my husband cannot call up the IRA administrator where I have my IRA and say, Stephanie's incapacitated, I'd like to withdraw $20,000. I'm going to need that money to pay for home health services to take care of her. The response that he's going to get from the IRA administrator is, please show us that you have a durable power of attorney for your wife, or if you don't have that, please show us proof that you became legal guardian. Show us a court order. So that's an example of why simply by being married doesn't give the spouse authority to deal with assets that are in the individual's sole name. And an IRA is just one example of many different types of assets that can never be put in joint names. So any kind of retirement plans, IRAs, 401ks, SEPs, cafeteria plans, are unique to the individual, to the employee. We can't add our spouse's name on as a joint owner. We could add them as a beneficiary to inherit when we die, but there's no way for them to be a joint owner. So it's a very important reason why everybody should have a durable power of attorney. If we don't have the durable power of attorney, it's very likely that bills are going to go unpaid and may even go into collection unless family members or friends are willing to pay those bills until there can be a guardianship put in place. If we don't have a durable power of attorney, it's also likely that there can be missed opportunities to change investments, and that would be horrible, especially if the market was showing that a particular investment was dropping in value or it was a great time to sell. Without having a durable power of attorney, it can also be very challenging to stop any financial exploitation that may be occurring. So without the durable power of attorney, what we are left with is going to court and pursuing what's called a guardianship. Now, guardianship is referred to as a measure of last resort simply because we prefer that people make choices, create a durable power of attorney, and get to choose the people that they would like to make their financial decisions. We also call it the measure of last resort because by having the durable power of attorney, it helps keep more privacy in people's lives. The document is generally not filed anywhere and generally wouldn't be recorded in the public records unless there was a need to sell real estate that the person owned. Then the durable power of attorney would be recorded as part of the closing transaction. So guardianship can take time to put in place, and this is important to understand. Absent a true emergency, it can take 4 weeks from the time papers are filed with the court to get a hearing. And after the hearing, it could take another week or two before we get court orders signed by a judge appointing the guardian. So on average, we're looking at a 6-week delay from the time the pleadings are signed and filed with the court. With a durable power of attorney, in comparison, we simply go through a very short process of presenting the power of attorney to the financial institution, having the agent sign an affidavit to have their authority recognized. And so it's far better to use the durable power of attorney because it takes less time than a guardianship. Another benefit of the durable power of attorney is that the agent and the client are not paying ongoing costs, ongoing legal fees. And there will be ongoing legal fees in a guardianship proceeding because even once the guardian is appointed, the guardian must be represented by an attorney. And that is a requirement in all states unless the guardian happens to be an attorney themselves. So there's an ongoing expense, which means there's going to be less money available for the care of the individual that's incapacitated. So another reason to encourage people when they're healthy and they're still mentally competent to put the durable power of attorney in place. And as I already mentioned, privacy is probably the most valuable thing that we all enjoy, and that unfortunately can be lost because many of the court documents that are filed become a public record. And in Florida, we started doing electronic filing of legal documents with the court back in 2012. So anybody can just be in their home, go online to the court records, and see a lot of the documents that are filed. So for these reasons, I do encourage all consumers to have a durable power of attorney. Now, what can happen if a person decides they're going to do it themselves? They're either going to go to a stationery store like Office Depot, they're going to go on the internet, maybe to LegalZoom, and they're going to do it themselves. Well, the first danger to understand is that it's a form, and it's never going to be tailored to any person's individual needs or goals. The second danger is that a form doesn't provide advice, experience, or knowledge on the law that truly every person needs to have. Not everybody is the same. Not everybody has the same assets or the same family dynamics. So unfortunately, the person is going to lose that opportunity that they would have had by consulting with a knowledgeable either elder law attorney or estate planning attorney. Probably the biggest danger of doing it yourself is that if this form lacks a specific type of authority, it means that the fiduciary cannot take that action. And the danger is that at the time the document needs to be used, if the individual no longer has capacity, then they cannot sign a better prepared durable power of attorney. That window of opportunity will have closed, and we may unfortunately only be left with the option of pursuing a guardianship. One of the most frequent examples that I see and I get phone calls about every week is that an older adult is incapacitated, has a chronic illness, needs to qualify for Medicaid assistance to help pay for the cost of their care. And unfortunately, the durable power of attorney doesn't contain language allowing the fiduciary to create what's called a qualified income trust. This is a type of trust that is required if a person who applies for Medicaid has too much income to qualify. So in order for them to be approved for Medicaid, this legal document needs to be prepared and a bank account has to be opened for their income to be deposited. Unfortunately, when the language to create a Medicaid income trust or the language to create an irrevocable trust is not in the durable power of attorney, we can't do that. So we have to go to court, get a guardian appointed, and then obtain court approval for the guardian to create the trust for the Medicaid applicant. Unfortunately, that's going to take time and it's going to cause an expense to be incurred that could have simply been avoided had the person gone to an experienced attorney who would have included that language in the document. So before I had briefly mentioned that one of the advantages to having the durable power of attorney is that you're not making somebody else a joint owner of your assets. And I think it's important to take a minute and talk about what some of those dangers are, because most people wouldn't think that there is a danger to putting somebody else's name as a joint owner on an account or another kind of asset. So the first thing to understand and appreciate is that when you put somebody else as a joint owner, that person has equal rights as do you to go into that account and make withdrawals. The bank or the brokerage house does not need both people's consent to allow withdrawals. Most people are surprised to hear this. What happens if there is an unanticipated event? Something that happens to the joint owner that the client never anticipated. For example, what if they put their son or daughter's name on an account with them, and then the son or the daughter are in the process of getting a divorce? Well, believe it or not, that account is going to need to be reported in the divorce proceeding as being an asset of the spouse. And it means that potentially half of that account could be lost in the divorce proceeding. Even though that adult child may never have contributed to the account, and all the monies in the account can be proven to be the asset of the parent, legally, that child is a joint owner. Now, another thing that we might not expect to happen, but could, is if the joint owner, and let's again use the example of the adult child being on the account, let's say that adult child has a business and the business doesn't do well, and creditors have been accumulating and the child cannot pay back the debts. That child might go and consult with a bankruptcy attorney and file for bankruptcy to get out from under the debts. Again, we end up with a similar result, which is that joint account has to be reported in the bankruptcy petition. And half of that account could be subject to the creditor claims. What if the joint owner causes a car accident, gets sued? Maybe there's even a judgment above the policy limits, or there's another kind of judgment entered against the joint owner. Any of these things can potentially subject half of that account to being lost. So while these are unintentional results, things that we would never imagine could happen, they can happen. So the lesson to be learned is it is far safer to have the durable power of attorney rather than putting somebody's name as a joint owner on the asset. So now we're going to talk about what changed in Florida law in 2011. Well, we had a lot of changes that year affecting the durable power of attorney statute. Some of the changes were meant to protect the consumer, and some of the changes were meant to protect the financial institutions. And we're going to walk through these together. So one of the first things that happened as a result of the law that was passed is that attorneys can no longer write for a client what we once called a springing durable power of attorney. So I'm going to give you an example. Sometimes a younger person would come to me and they would say, I don't want the fiduciary I'm naming to start to make any financial decisions for me. I'm healthy, I'm young, I want to be in control. So what can I do? Well, we could have offered that person the opportunity to have a springing durable power of attorney, which meant there would be language in the document saying this durable power of attorney is not effective until my physician examines me and signs an affidavit stating that I am unable to handle my financial affairs. So that was a great solution for people that didn't want their fiduciaries to start to step in. However, because that was taken away, the new law that is currently in place in Florida says that once we sign our durable power of attorney, it is effective at that moment. So for that reason, if you don't want your fiduciary to start to act for you, you don't want to give them the original document, and you also do not want to give them a photocopy, because the photocopy is considered by law to be as effective as the original document. So you'll want to tell your fiduciary that you had this done, and where you are safeguarding the document, should something unexpected happen to you, they need to be able to find it so that they can have their authority recognized and be able to assist. Now, the process of getting authority recognized starts with presenting the document to the financial institution. Do not be surprised if the financial institution asks you to sign an affidavit. This is permissible in Florida, and this is really intended to protect the financial institution, but is also intended to protect the client. The first thing that is stated in the affidavit is that the individual who owns the account is alive and not deceased. And as we talked about a little while ago, a durable power of attorney ends on death. So we don't want somebody using a durable power of attorney after they know that the individual has died. And the reason that this language is put in the document is a long time ago there were some situations where unscrupulous people knew the individual had died, went to the bank, and used their durable power of attorney to clean out an account. And when the bank then learned that the individual had already passed on, the bank was sued by the ultimate beneficiaries who would have inherited the account. So that's the reasoning behind why the affidavit states that the individual, what we call the principal, who owns the account, is still alive. The second statement contained in the affidavit says that the person who gave the power of attorney didn't cancel it. They didn't change their mind and revoke the document. Again, this is meant to protect the consumer in case the person presenting the document is attempting to commit a crime. And the next statement in the affidavit says that there is no guardianship pending for the person who gave the power of attorney. And this is very, very important, and here's why. Our law says that once a petition to determine a person's incapacity or a petition for emergency guardianship is filed, it results in temporarily suspending the authority given under the durable power of attorney document. So that authority remains suspended until the judge can listen to the evidence, hear testimony, and decide whether or not the durable power of attorney is a less restrictive alternative to doing a guardianship for financial decision making. So those three statements in the affidavit are meant to protect both the consumer as well as the financial institution, and the financial institution is allowed to require the fiduciary to sign the affidavit. If the fiduciary refuses to sign the affidavit, their authority will not be recognized. One of the things we're going to talk about as we move into a discussion of powers, things that you can do under a durable power of attorney, it's very important to understand that if the person you're naming as your fiduciary could in any way financially benefit from decisions they're going to make, there is a perceived conflict of interest. So it's very important that the durable power of attorney say whether or not the client is waiving that perceived conflict of interest. And it not only protects the client, it protects the fiduciary from anybody else making an allegation against them that they're misusing the authority under the document. So now we're going to talk about what we refer to as superpowers. This is the other thing that changed in the 2011 Florida law. So the legislature decided that there are some very high levels of financial decisions that could be made. And so it's important that every consumer decide, are they going to give permission to make that kind of financial decision, or are they going to withhold that authority from their fiduciary? So we're going to walk through each of these superpowers together. The first important superpower is the ability to create a trust for the person who's incapacitated. So an example might be that prior to becoming incapacitated, the person did not have a revocable trust. And now their fiduciary steps into the picture, looks at all their assets, and consults with an attorney whose advice is to create a trust for purposes of avoiding probate. Or maybe the benefit of creating a trust is a tax purpose. Maybe there's a tax benefit. Well, the only way the fiduciary is going to be able to create and actually sign a trust document for the person who's incapacitated is if permission is given to do that in the durable power of attorney. So when I meet with a client and we talk about these superpowers, the client is making a decision whether to give authority or withhold authority. And when they sign the document, they are going to initial next to the superpower, either saying, yes, I give that authority to my fiduciary, or no, I don't give that authority to my fiduciary. So it's really important that consumers understand what these superpowers mean and have very practical examples so they can make an informed choice. The second type of superpower falls under the category of asset protection planning. Now, this can include things like Medicaid planning, should somebody have a chronic illness or disease that they're concerned how are they going to pay for their care if perhaps they don't have a long-term care insurance policy. So in order to do Medicaid planning or to plan to obtain veteran benefits, it's going to be important that they delegate the ability for the fiduciary to engage in asset protection planning. Or it could be tax planning. Perhaps somebody is very wealthy and there needs to be a high level of tax planning to protect their assets. A third type of superpower is the ability to modify an existing trust. Now, why might somebody want to do that? Well, there's a whole host of reasons. What if when their trust was written, the federal estate tax laws were different and they were not in a taxable category, and then the law changed? Perhaps the federal estate tax exemption was lowered by Congress, and now they're in a taxable category, but unfortunately, they're incapacitated, so they can't amend their trust. They can't modify it to include tax planning language. Well, that would be a very good reason to give permission to the fiduciary to modify a trust. Or perhaps maybe there needs to be a change of beneficiaries. Maybe there's a new beneficiary that's just been born or come into the family through marriage. So those might be good reasons to delegate authority to modify an existing trust that the consumer has. A fourth type of superpower is the ability to make gifts. So the best way that I can explain this is if while you're competent, you have a pattern of gifting. Maybe you gift on birthdays, holidays, special occasions like a wedding, an engagement, a christening, a bar bat mitzvah, or perhaps you have a pattern of tithing to a religious organization or donating money to a charity. The question becomes, do you still want gifts to continue once you become incapacitated? If you do, then that's a reason to delegate authority to your fiduciary. So you would want your durable power of attorney to indicate, yes, I'm giving this superpower to my agent. Whereas if you don't want that to continue, your choice, your decision would be, no, I'm not delegating that type of superpower. Now, if you do decide you want to delegate the authority to make gifts, you also want to think about, do you want to identify or in any way limit the recipients of the gifts? And do you want to indicate or limit the amount that can be gifted? So all of that can be tailored in the document to meet the needs of the client. The fifth type of superpower is the ability to either create right of survivorship or change right of survivorship. So this is very important for people to understand. Right of survivorship means that there are multiple joint owners listed on an asset, and should a joint owner decease, the surviving joint owners automatically own the decedent's share. The decedent's share will not go to other people through a probate. So whoever might be named in a last will and testament or a trust agreement won't inherit that share. It goes automatically to the other joint owners. So this becomes a very important decision to make. We want to understand, if I haven't created joint ownership, do I want that done once I'm incapacitated? Or if I've already put a joint owner on an asset, would I want somebody to change my decision after I become incapacitated? I may not. So this is a very serious superpower that we want to give consideration to. The sixth type of superpower is similar. It's the ability to either create or to change a beneficiary who is designated on a life insurance policy. So sometimes clients, believe it or not, forget to name a beneficiary on a life insurance policy, or they only name one beneficiary and they've never named a secondary, an alternate. And this is important, especially if the primary named beneficiary has passed away. If we don't have a beneficiary, that asset is going to go through a probate process in order to get to the ultimate beneficiary. So there could be an advantage to saying in the durable power of attorney that you give permission to your fiduciary to designate a beneficiary as long as it's a person named in your will or your trust, so that it reflects your estate plan. But if you already have a primary and a secondary beneficiary, do you really want your agent to change who that is? Maybe not. So we want to give careful thought to this type of superpower. The seventh type of superpower is the ability to create or change a beneficiary designation on any other kind of asset other than a life insurance policy. So that would include our bank accounts, our investment accounts, even individually held stocks or bonds. It could even include annuities that we might own. So we want to go through the same thought process of, do we have a beneficiary? Do we have an alternate named? Do I need to change who that is? Perhaps I'm creating a special needs trust for a beneficiary who's disabled. You know, things happen that we can't forecast. What if the client, after signing the special needs trust, walks out of my office and becomes incapacitated before they designated the special needs trust as a beneficiary on an asset? Well, that might be a really good reason to give permission to the agent to do that. So we can tailor the superpowers to meet the needs of each client. The 8th type of superpower is a waiver. A waiver means to give up the right to something that you're entitled to. So here it's asking, do you want to waive your right as a beneficiary of a joint survivor annuity? Now, most people I know don't want to give up the right to inherit anything, especially if what they inherit is going to enable them to improve the quality of their life. So again, it's an individual decision for everybody, but one that they need to understand. The 9th and a very important superpower is whether you want to give your agent the ability to disclaim property you could inherit. Let's say you have a relative who's passed, they named you in their will or their trust, but at the time they've passed, you're incapacitated. So you can't make the decision of either accepting the inheritance or giving it up, what we call disclaiming. Now, again, most people might say, well, wait a second, Stephanie, if their life could be improved by accepting the inheritance, why would they want their agent to disclaim it? Well, we're going to go back to tax issues. And if the person who's going to inherit might already be in a federal estate tax position, it might not be advantageous for them to inherit more money because then they need to do more estate tax planning. So for that person, we might want them to not delegate the superpower. We might want them to disclaim. So it's a very individual-based decision, but we want people to understand that disclaiming means to give up something that they're entitled to receive. And the 10th and final superpower that came about from the 2011 law is waiving statutory rights to inherit. So under Florida law, we have a legal right to protect a spouse of a decedent. It says that a spouse cannot be disinherited unless the couple agree to that in writing, either in a prenuptial agreement or a postnuptial agreement. So if the spouse is not mentioned in the will, they are protected. Under Florida elective share law, they're entitled to 30% of what the decedent owned, whether it goes through probate or it doesn't go through probate. So most people wouldn't want to waive that right, and so it's important for them to understand this. There's another right under Florida probate law to what's called a family allowance, which means that while the probate of a spouse is pending, if the surviving spouse needs money to live off of, they are entitled to receive a family allowance during the pendency of the probate. So these are very important rights that really I would not recommend that anybody give up or waive through their durable power of attorney document. Now, it's also important to understand there are certain limitations in addition to the superpowers. So there are certain things that the agent named in the power of attorney can never do. There's no way to delegate authority to them. So one of the first limitations is that if the person who's incapacitated had a contract with somebody else to provide personal types of services, the fiduciary cannot perform those duties under the contract. A second limitation is that the fiduciary cannot sign an affidavit that would require them to have personal knowledge that's only within the framework of the incapacitated person. So they can't sign an affidavit that only the incapacitated person would have knowledge of. The third type of limitation is a fiduciary can't vote in an election for the person who's incapacitated. You can't go to the election booth with the durable power of attorney and say, I'm going to cast a vote for Mr. Jones because he can't be here. We don't allow that. And the fourth type of limitation is that the person holding the power of attorney cannot sign a will for the person who's incapacitated. That is just something we do not allow because there's no way to know what was the intent, what was the estate plan that this person had in mind. And similarly, there's also a limitation that prevents the fiduciary named in the power of attorney from attempting to sign a codicil. A codicil is a way of amending or changing an existing will. We don't allow the fiduciary to in any way change the existing will by signing a codicil. We want to uphold and protect the estate plan and the intention of the testator. And the last limitation is we don't allow the fiduciary to exercise any powers given to the person that was incapacitated who might themselves been serving as a trustee or a fiduciary for somebody else. You can't automatically be delegated authority down the line for somebody you don't know and for whom you're not named in their document. So I'd like to share with you now some tips of how do you prepare or help your clients prepare in advance to create a well-sounding, durable power of attorney that's going to work when they need it to work. So we start with identifying who the trusted individuals are, and the best way to do that is to encourage the client to have an open dialogue with that person. And it doesn't have to just be family. Florida law does not contain any restriction on it being a family member. It can be a best friend. It can be a trusted individual, perhaps your accountant, maybe even your attorney could serve as a fiduciary. But it's important to have the conversation rather than it come as a surprise after the document is signed. It gives the other person the opportunity to think about the responsibility that they're taking on and be certain that they're willing to serve in that role. I do encourage clients not to simply resort to, I'm going to name my oldest child because that just seems to make the most sense. It's not about who's the eldest or who's the youngest in the family. It's about matching a person's skill set with the responsibilities they're being asked to take on. So you want to think in terms of who is very responsible, mature. It doesn't mean the person needs to have a degree in finance. It doesn't mean they have to be an accountant or an auditor, but you want somebody who's responsible and who knows that anything they don't know, they're going to consult with a qualified professional, whether it's the financial advisor, the lawyer, or the accountant. And don't limit your options for naming a fiduciary based upon geography. There's no requirement that the fiduciary has to live in the same state or even in the same town or city. It's more about, are they willing to do what it's going to take? And since we do live in a world of technology, which has definitely proven to us in this last year that we've been living with the COVID-19 virus, we know that a lot of things can be done with technology at a distance. it's very important to think about naming an alternate. And it's simply about having a good management plan. And the reality is that there's no crystal ball to look into to know whether the person we name as our first fiduciary isn't going to get sick themselves or perhaps suddenly die. So we have to have that backup plan. And I definitely recommend naming at least 2 alternate fiduciaries rather than 1. If the alternate becomes ill or dies and you don't have that secondary alternate named, that's the time to seek good counsel and get a new durable power of attorney prepared. I strongly recommend that people don't wait until the last minute. Don't wait until your doctor says you're going into the hospital for a treatment, or you're not feeling well, or you just received a diagnosis that you don't know if the treatment is going to work or not. Do this while you're healthy. Do this when you're thinking clearly and you're making a sound decision. So at this time, I'd like to open it up to any questions that you might have. You're welcome to unmute your microphone, or please feel free to write a question in the chat box. Well, if there are no questions, I want to thank everybody who joined me this afternoon. And I'd like to remind you that we hold these webinars twice a month. You can go to the calendar page on my website, www.fl-elderlaw.com, to see what topics are coming up and to register. And in case you registered but you had to miss the webinar, don't worry. Just go to the recording page and you can download and listen to any recorded webinar.
Thank you, Stephanie. It was very good.
Oh, you're welcome. Did you have a question, Debbie?
No, thank you. You answered a lot of the questions. Thank you very much.
Oh, you're welcome. I also encourage you to download the free document checklist from my website on the Contact Us page. And it's a great way to start organizing and getting your thoughts down on paper. And we do have on that page a gift certificate for a 20% discount on the initial consultation. So have a great March, stay healthy, and I look forward to you joining me for future webinars. Thank you.
Thank you very much, Stephanie.